with unfolding events in Delta State since the recently held primary election of the People's Democratic Party, PDP. Ivwurie's leadership in Delta PDP is being questioned, as the party is now divided into camps, fighting themselves over who becomes the governorship candidate of the PDP in the state. The disqualification of Sheriff Ivwurie by Justice Taiwo of the Abuja Division of the Federal High Court to declare Olorogun David Edevie as the candidate of the People's Democratic Party has created confusion over who will represent the party in coming general elections. However, over the weekend, Governor Ivwurie, during the PDP rally in Isoko North local government area, dismissed the seeming disagreements rocking the party in the state over the outcome of the party's governorship primaries, saying there was no cause for alarm. Joining us on the show this morning, as we discuss the governorship tussle in Delta State PDP, is Victor E. Ebonka, Chairman, Ika Northeast Local Government Council, and Evans Ochukwu Ivwurie, former Special Advisor on Local Government and Chieftaincy Affairs to former Governor Emmanuel Uduaghan. Gentlemen, welcome to the morning show. Good morning, and thank you for joining us.
Good morning, Nabati. Thank you. Morning, Arise Television.
Thank you very much. Well, to both of you, is there cause for alarm in Delta State PDP, particularly with regard to the gubernatorial candidacy, in the matter that is now known as David Edevie versus Sheriff Ivwurie? I hope the pronunciation is correct. And considering the fact that, there is a court ruling on this matter already. So let me start with you. You are here with us in the studio in Lagos, Mr. Ivwurie.
Well, thank you very much. I will say straight away that there is no cause for alarm. Nigeria and the whole world is well aware that there was a court judgment by the Federal High Court in Abuja, where there's a definite, subsisting, and a valid judgment of the competent court of law that the candidate for the Delta State PDP gubernatorial election is Olorogun David Edevie. To that extent, there is no cause for alarm. The judgment is unambiguous and is very, very clear. And I think that the next thing is for INEC and the PDP to respect this judgment.
Well, let's come to you, Mr. Ebonka, Chairman, Ika Northeast Local Government.
Thank you very much. It is on record that there was a judgment, but we thank God for the Constitution that provides that when you disagree with any judgment, you go to the appellate courts. And that we have done. Our own reason for appealing this judgment is on the ground that the judgment is perverse. The judgment was arrived at unsubstantiated conclusions that have occasioned gross miscarriage of justice. Going to the issue as they were, proper, there is nothing new in the allegation against Sheriff Ivwurie. There have been several cases of this nature, and it has passed through the judicial gamut from the trial court to the appellate court. And their case is principally premised on the fact, on section 29.5 of the Electoral Act 2022, which is in pari material with section 31.5 of the Electoral Act 2010, to the effect that Sheriff Ivwurie submitted false information and fake educational qualifications to the party, PDP, in relation to his age, names, and educational qualifications. Suffice it to state at this level that the Supreme Court in decided cases have consistently maintained that for you to sustain and succeed in an action relating to falsification of certificates, there is a standard of proof. There is a basic evidential burden that is placed on you, Edevie in this case, to abuse before the court before you can succeed. And that they have not exercised at all in the trial court. And the trial court went ahead to decide these cases on the basis of mere affidavit assertions rather than trying these cases beyond reasonable doubt. Because it is the law that when allegation of crime is made in civil proceedings, it must be proved beyond reasonable doubt. It must be proved beyond. Section 135, 1 and 2 of the Constitution is instructive on this cause. Then there have been case laws litigated up to the Supreme Court on this issue, on the standard of proof, on the basic proof that you must prove to succeed in a case like this. And that is completely lacking in their case. That is completely lacking. I'll crave your indulgence to refer you to the Supreme Court authority. The recent of all these case laws is the case of Obaseki, APC versus Obaseki. The case is there, reported in 2022, 2 Nigeria Weekly Report, parts 1814. 2 Nigeria Weekly Law Reports, part 1814. This is what the Supreme Court has to say. This is what the Supreme Court has to say. To prove that the information in Exhibit PL that first respondent obtained a degree certificate from University of Ibadan in 1979 is false, would require evidence from the said university showing that he did not attend the said university or did not obtain the said degree from the university in 1979 or at all. And the Supreme Court has this to say: the basic evidence required to prove that the university degree certificate attached to the INEC form EC9 is forged. It's a disclaimer from the University of Ibadan that is said to have issued this certificate. The evidence required to prove that the A-level WAEC certificate, as it relates to Sherry's case, A-level WAEC certificate attached to form EC9 is forged. It's a disclaimer from WAEC that conducted the examination and issued the result and certificate. It is curious that the appellants did not produce evidence of any official disclaimer from the University of Ibadan of the degree certificate attached to form EC9 or any official disclaimer of A-level WAEC certificate by WAEC without evidence from the institution or body that is purported to have issued any certificate or other document stating that it did not issue the certificate or document, or that any part of the certificate or document is not made by it. It would be idle and useless to contend that it is forged. In the light of the foregoing, I hold, this is the Supreme Court speaking, I hold that the Court of Appeal correctly affirmed the decision of the trial court that the appellants did not prove their case by any standard of proof. The case of the appellants collapsed at the close of their evidence, and there was no case for the defendants to rebut or defend. It is clear. As I stand here today to speak, I will not say anything that I will not back up with the provision of the law. Everything I will say, I will back it up with Supreme Court authority. It is also their case. The basis of their conclusion that the WAEC result was fake is because there is the date indicated in the WAEC result was stated to be 1979 as against his declaration of age that he was born in 1963. And this he has clearly, in 2003, deposed to an affidavit correcting this irregularity. But assuming that he did not correct this irregularity, is there any provision of the law that places age limit to which anyone can sit for an examination? Is there any provision of the law that places age limit through which anybody can decide to pursue his educational career? No. And what did the Supreme Court say in an issue as this nature? I'll take you to the case of Ivwurie versus PDP on this call for you to see what the Supreme Court said in this case. And another case of Mai Haja versus Gaidam, reported in 2018, 4 Nigeria Weekly Report, part 1610. See what the Supreme Court has to say.
Mr. Bonka.
Well, I want to crave your indulgence. Let me just conclude on this issue, please.
This is not a court session.
These two authorities.
This is not a court session, Mr. Bonka. I wanted to draw your attention to that. So these authorities...
For us to just make the public to understand.
Okay. Because we are not going to pass judgment one way or the other. Okay. If you could just do that briefly.
Yes, please. I crave your indulgence. Just your indulgence. Just briefly. Look, see what the Supreme Court has to say in Maharaja versus Gaidam. My understanding of subsection 5 of section 31, section 31 is in pari material with section 29(5), upon which their case is premised, is that the false information complained of must relate to the constitutional requirement for election into the office in dispute. In this case, the requirement of 177B and C of the Constitution, as regards the age of the first respondent, as regards the age of the onus was on the appellant to prove that at the time he contested the election, the first respondent had not attained the age of 35 years, as required by section 177C of the Constitution. If there is any discrepancy, as they are alleging, if there is any discrepancy in the age of the candidate, it must have a bearing to the constitutional requirement before it can have the effect of disqualifying him. In the face of all these Supreme Court decisions, the trial court went ahead to deliver a very perverse ruling, unsubstantiated conclusions, unsubstantiated speculations that has occasioned a gross miscarriage of justice. It is on the basis of that we are presently on appeal. And I tell you today, that case will not stand appeal. It will never, it must be set aside. There are other fundamental flaws in that case. And allegation of fraud is being made. And you are trying at the allegation of fraud on the basis of mere assertion in the originating summon. The law is that when the allegation of fraud is made, it must be proved beyond reasonable doubt. Section 135(1) and 2 of the Constitution of the Electoral Act is instructive on this score. And the proof beyond the reasonable doubt that you require is not a proof that you can ventilate on the basis of mere assertion in the affidavit evidence in the originating summons. In the originating summons, you must go beyond. You must go beyond. You must go beyond to ensure that. You must go beyond to ensure that you ventilate. You prove beyond reasonable doubt by filing a writ of summon and call evidences and call witnesses.
Okay.
And in this case, the witness that is necessary to report this allegation is the school. It's a disclaimer for the school. Okay. And all these are lacking in their cases.
Okay,
and they are coming to say that he forged documents.
Mr. Bonka, I think you've made your case, okay? All you are saying is that the Court of Justice, Taiwo.
And I still have several cases.
No, I mean, this is a conversation. We'll continue.
Right.
Yes, Tundum.
I think I'll give you a minute to catch your breath there, Mr. Bonka, and I'll come to our guest in the studio here, Mr. Ivwurie. So the recurring theme in Mr. Bonka's submission, since we do feel like we're in court this morning, is that you have failed to reach the standard of proof. What is your response to that?
Well, thank you very much. I need to spend a little bit of time to try to take care of the issues as presented by Barrister Bonka, one after the other. I'll start with to say that, first and foremost, he's a lawyer, and he's the local government chairman, and also the chairman of Argon. But the fact is that there is a valid judgment, except he's disputing that. And from what he has said, he has not disputed that there is a valid court judgment, that there is a subsisting court judgment. He has not disputed that. All he has bothered to do here is to quote a bunch of Supreme Court and the Appeal Court and High Court authorities. But very unfortunately, this is not the court. And they had all the ample time. He had all the ample time to go to the court to defend his client. And his client hinged his case on technicality. Entirely on technicality. All he went to say at the Federal High Court is that the case is premature and that the Electoral Act forbids David to bring the case to the Federal High Court until Oborewori's name is sent to INEC. That is, David should wait for the trailer to kill him. Then now, after when he's dead, then he cannot wake up and then take the document until the document is taken to INEC. That is their case. All they did was technicality. They didn't. Oborewori did not defend the weighty allegations, very, very serious allegations that were leveled against him, in line with the Constitution of the Federal Republic of Nigeria, with the Constitution of the People's Democratic Party, and the guidelines for conduct of party primaries. that he is not qualified. He knows very well, Mr. Ibonka knows very well that Sheriff Oborewole did not go to school. He knows very well that the WAEC in question that we're talking about and the first school living certificate does not belong to Sheriff. He knows very well. And instead of going to court to defend this weighty allegation in the court, or they spend all their time on the technicalities. And right now, the technicality has suffered a major calibrated technical accident. It's like somebody who is falling from 35 feet above, below the sea level from an aircraft. And I think he still has a lot of time. As I said, this case is now in the Court of Appeal. But before us, there's no stay of execution. What we have is a notice of appeal. Both the notice of appeal, if they have it, and the stay of execution has never been argued, so there's no stay of execution. And it bothers me like every Nigerian that Barrister Ibonka will be on the national television to begin to talk on this issue when this is not a court. He's a lawyer, he should go to the court and defend the issue very, very properly. But what we have today is that Olorugu David Ivwurie is the candidate of the PDP. And it is a very, very big shame, Mr. Abati and Rice Television. It's a very big shame, it's a very, very big disgrace that the two major institutions in Nigeria that should strengthen democracy, the People's Democratic Party and the Independent National Electoral Commission, INEC, will flout a valid court order that is given by a court of competent jurisdiction in Nigeria, that David Ivwurie should be recognized by the party and the INEC as the candidate of the party. It's a very explicit judgment. And these two critical and vital institutions are disobeying this order. Is a very, very terrible thing. And I want to invite all the major agencies in the world, United Nations and agencies in Nigeria that strengthens democracy, to look at the suspicious activities of INEC and PDP as it concerns this case, where we have a valid court judgment. And one of the biggest shame is that PDP came up with a public statement a few days ago, saying that they submitted the name of Sheriff Oborewole to INEC on the 8th of July, a day after the judgment. And PDP and their lawyers were in the court. Oborewole and his lawyers, they were in the court when Justice Taiwo delivered the judgment. And they immediately disobeyed the judgment that they were part of. They were in court when it was delivered. By their statement, the press statement of PDP, they said that the next day, being on the 8th of July, a day after the judgment, PDP went ahead and then sent the name of Sheriff Oborewole to INEC. Somebody who the court has ruled that does not have the basic qualification, secondary school living certificate, or it is equivalent. This is the minimum required by our law to contest for the office of the governor of Delta State. And Oborewole does not have this document. The one he is parading, the West African school certificate that he is parading today, carries the name of Francis O. Oborewole. And the age on that was that he is parading is 12th of November 1979. Whereas, as confirmed by Mr. Ibonka now on national television, that Sheriff was born on the 19th of June 1963. And we also know this is a national television, and I want Nigerians to know that it is a tradition that if there's an error, and we know that there cannot be error on your WAEC, there cannot be error on the date, the month, and the year. And if there's any error, it is the candidate who wrote the exam that should approach WAEC. Is either you go there or you write to them and say that there's an error on my WAEC. This is the WAEC you are seeing on here on the television. If there's an error on your date of birth since 1979, you ought to write to WAEC to make the correction. The reason Ivwurie did not write and never wrote to WAEC is because he's not the owner of that WAEC. And he knows that if he writes to WAEC, WAEC will expose him. He will be arrested because that is not his certificate. Also, if you notice also on that certificate, the one is submitted to INEC in 2018 that Ivwurie submitted, and is still submitted now to WAEC in this on the 8th of July, stated that he enrolled for 5 subjects. But if you look at the surface of that WAEC, this is it. If you look at the surface of it, you will see that he tried to mutilate some of the subjects. He defaced it. He defaced it to show that he enrolled for 5 subjects. Then, if you now look at the one that is on the portal of WAEC, if you check it, that one shows that there are 8 subjects enrolled. So this man forged this document. He forged a WAEC, and he could not go back to WAEC because he's not the owner of that document. And I'm so appalled and disturbed that a lawyer like Barrister Victor, my very good friend, who every Deltans knows his classmates from primary school, secondary school, university, and his colleagues in NYC. And nobody knows any of Sheriff Ivwurie classmates from primary, secondary school, university, all these things. Nobody knows his classmates, nobody knows his teachers, nobody knows his principal. And he's here. This is a pure moral decadence.
Wow.
That my friend will begin to defend an uncertificated illiterate. This is what is shown here. There is no certificate.
Mr. Ivwurie, you're here to state your claim, and so is he. He's within his rights to do that. Mr. Bonka, your response to weighty allegations against you personally, against your party, the People's Democratic Party, and their democratic credentials, and against our election umpire, INEC. Your response to all these allegations.
Thank you very much. I have made up my mind not to come to this screen and talk out of sentiment, out of bias, and speak maliciously, as Evans is talking. You need to let the world know the truth. You need to present the factual situation to the world and back it up with the provisions of the law. Let's not forget the case of Salisu Buhari in 1999, the then Speaker of the House of Rep, where it was alleged that he forged the Toronto certificate. They had to do a letter to the university in Toronto, and they responded by disclaiming that he did not have that certificate. But all these institutions that Sheriff attended, they are within the shores of this country. They have not shown by their case, as was heard by the Supreme Court, the basic evidential, but the basic evidence that you need to prove. They have not shown by their case that I have written a letter to WAEC and that WAEC has disclaimed it. They have not shown that I have written a letter to the primary school Alegbo and that Alegbo has disclaimed it. They have not shown that they have written a letter to Orareki Grammar School and Orareki Grammar School has disclaimed. They have not shown that they have written a letter to Ambusali University and they have disclaimed. They have not shown that they have written a letter to Delta State University that issued the master's degree and they have disclaimed it. And you are coming to the screen to say that I know that the certificates are forged. Is it by coming to say it merely? Show us the hard evidence that these certificates were forged. You have not even shown us that you have written a letter to these institutions. You have not even shown us. And you have not even shown us a disclaimer by these institutions. Rather, you have admitted that the result is in the portal of the WAEC. The photograph of Sheriff is there in the portal of the WAEC. The burden is on them to prove on the strength of their case, not on the weakness of the defendant's case. They have not crossed the threshold of proof. I don't want to come here and start talking out of sentiments. I want to talk factually. I want to talk on the basis of the law. The similar issues as this has been litigated upon has passed through judicial circle, High Court, Court of Appeal, and Supreme Court. And Supreme Court has laid down the principles. These are the things that you must prove. If you are alleged that somebody forged his document, get a disclaimer from the institutions. Obaseki case that I just cited. APC vs. Elekebe. Get a disclaimer from these institutions to the effect that these documents were forged. They have not done that. It is not their case at the Federal High Court. They did not exhibit anything as such at the Federal High Court that WAEC has said that they did not issue this certificate. It is not of Sheriff to go to WAEC. It is of them to prove. The burden of proof is on them. And their case is devoid of any of this proof. Rather, what they succeeded in doing and what their stock in trade is to just come out in the social media and be talking in an uncouth manner. In an uncouth manner, referring to me that I know that somebody's certificate is forged. If I want to find out that somebody's certificate is forged or not, what I do is to do a letter to the issuing authority to find out whether the result they issue, if some Nigerians could go as far as Toronto, outside the shores of this country, they could not even go to WAEC office in Lagos or in Abuja to verify whether for WAEC to disclaim safe. They could not do that. They have not done that. They have not crossed the threshold of proof. They have not crossed that. On his assertion that the case was not defended, let me tell you, the case, we rebutted all these assertions of theirs. If you say I forged my document, what evidence do you need from me? I will just tell you, I didn't forge my document. The onus is on you, as was heard in Obaseki's case, to go to these institutions and get documents from these institutions to get a disclaimer, to say that this result is forged, as was done in Salisu's case and several other cases. In Obaseki's case, University of Ibadan came and said, we issued this certificate. They have not done that. It is not part of their case. It's not part of their case. And the Supreme Court has said that cases of this nature, where you are alleging crime, it must be proved beyond reasonable doubt. They have given the basic evidential proof that you need to prove. Get a disclaimer from these institutions. They did not do that. And the trial court went ahead to base its findings on mere assertions in affidavit evidence, and irreconcilable assertions, contradictory assertions. They said we forged. We said we did not forge. And the trial court went ahead and looked at the documents as exhibited without any proof from the issuing authority, from the schools that issued these certificates, in the absence of proof, and went ahead and delivered a perverse judgment that occasioned a miscarriage of justice. It is not of them to sit within the precinct of their bedroom and conclude that because the age is like this in this certificate, it is forged. What? The Supreme Court has also ruled on the issue of age, Agi versus PDP. All these issues has been litigated upon and decided on by the Supreme Court. I don't want to talk out of sentiment. If we want to talk out of sentiment, we'll be throwing stones at ourselves because we know our antecedents. We know our antecedents. We know our characters. So with due respect to Evans, he should be caught in the use of language. And he knows the truth. They may have written to WAEC. Let me tell you the truth. If you come to brief me as a lawyer in a case like this, the first thing I will do before approaching the court is to write to the issuing authority to say whether this certificate was forged or not. They have done that. He cannot deny that. They have written to WAEC, and WAEC has validly told them that these certificates were issued by me, and they could not present these facts. WAEC is not outside the shores of this country. Just a mere letter. They will reply you. They will disclaim. All the issued authorities that issued these certificates, they are there. They will reply you. And they have not done all that. It's not enough to just come out in the television and start talking sentimentally, biasly, and maliciously, like Evans is doing. Okay. That is not the case. Okay. That is not the case. They need to write on the INEC, because I have not answered on the issue of INEC obeying the judgment. What is novel in this case? Anambra State case is a case study. A case like this happened in Anambra State. There was a ruling against Soludo. The ruling was on appeal. And the INEC, when they published, like they did recently in Delta State, they decided to leave the names of the candidates blank, pending the Court of Appeal decision. In the face of a pending motion on notice for stay of execution and notice of appeal. Don't forget that these motions are pending in order not to force a first accompli on the court, in order not to overreach the decision of the court. INEC, as a responsible institution, decided to wait for the outcome of the motion, the pending motion for stay of execution. And it's not new in this case. It was done in Soludo's case only recently. So why are they making heavy water of all these issues? You are saying I'm forged by certificate, and the institutions are there. From Ughelli to Orareki is less than 40 minutes drive to Ekpoma and to others, and you have not even shown us that you have written to WAEC that this is what WAEC said, that the document is forged, and the onus is on you to prove. It is not on me to prove. I don't even need to report your assertion because you have not crossed the threshold of proof.
Okay.
It's not enough to come and say Eboka knows that the certificate was forged. This one knows that the certificate was forged. No, talk factually. Yeah. Talk on the basis of the law.
Okay, Mr. Ebonka.
On the basis of law. Don't just come out and start talking randomly.
Okay.
In the first,
Mr. Ebonka.
On TV.
Mr. Ebonka.
Thank you.
Both of you belong to the same party. about two different
factions
of the party. Are you concerned that, the PDP may have unwittingly lost the election before the election? In a gubernatorial election in Delta State that has people like Great Ogboru, Senator Ivwurie, Omo Agege, Agbi, there's Agbi also of NNPP, that is there. All of them of the right, extraction by the calculations in Delta State at the moment. Are you worried about that? Because while the PDP is fighting over who is the authentic candidate, the other parties are having a chance to sell their own candidate. And don't forget, that mega rally that was held in, is it Ozoro?
Ozoro, yes.
Ozoro, yes. It was boycotted by Jameson and Ivwurie, who is a major factor in PDP politics in Delta State. Emmanuel Uduaghan, the former governor, was not there. David Ivwurie was not there.
Senator James Manager.
James Manager, yes.
The only senator that represents
James Manager.
District.
He too was not there. So the party is so divided, and it's not as if these people are inconsequential. So even if we win at the Court of Appeal, has the PDP not lost the election already?
Well,
that is not correct.
I would like to
that these personalities you called
I would like to weigh in if you will allow me to make a clarification to some assertion.
No, let him finish. Let him go ahead. Hold on.
No, this is my time. If these personalities you called did not attend the rally for one reason or the other, which I think has nothing to do with the issue in the party. But you must also note that the minority leader of the House of Reps was there. All the members of the House of Rep in PDP were there. Honorable Victor Wokolo was also there. And all the key leaders in the various local government areas were there. The rally was a huge success. I'm not unmindful that there is issue amongst us. But the popularity of PDP in Delta State is so overwhelming that in spite of this problem, the opposition parties cannot take advantage of it and succeed. The Evans is my brother, he's in PDP. Undemocratic is my leader, he's in PDP. At the end of the day, when the Court of Appeal rules, which I know they must definitely rule against this this perverse judgment, and I know that when they rule, we will come together as one and we will deliver Sheriff Oborevwori in Delta State. We are not undaunted by issues that are happening. We are one. We are still indivisible. We are still committed. We are still popular. It's only PDP. There is only one party in Delta State, and that is PDP. No any other party on this call. Thank you.
Okay, Mr. Ivwurie, you are going to respond to him.
Yes. Mr. Bonka remain my friend, and both of us remain members of the People's Democratic Party. But I think that we must try as much as possible to come back to the issue, to focus on the issue. And the issue being that Mr. Bonka knows very well that is subsisting and a valid court judgment. He also knows that the attempt to begin to go into mega rally at a time where the party is totally and extremely polarized and divided, and you are coming to justify that the people you mentioned that were at that rally, even the leadership of the party from that senatorial district where the rally held, none of them was there. The only senator that represents Delta State, and the only, as we speak today, and he's from that senatorial district, and many of the House of Representative members, they were not there. The leadership and the key stakeholders, the critical leaders of the party, they were not there because everybody is angry. But to try to come back to this issue is that I have a lot of respect for Barrister Victor, and I know that he is not a television studio lawyer. I know you are not a TV studio lawyer. I know you are a lawyer, and I know you can go to the Court of Appeal and bring out all of these points that I consider to be ill-fated, because you are bringing them now when you have all the opportunities to present them. When David Ivwurie filed his petition before the Federal High Court, he made all these weighty allegations. And you are telling me that, I am telling you that your certificate, your WAEC is not correct because the name on the WAEC certificate and the date of birth does not belong to you. and you are saying that you are waiting for me to go to WAEC, to go and to write to WAEC and all this. I think that this is an aspersion on the integrity of this of the so-called sheriff. It's an aspersion. A very huge aspersion is being casted on your integrity. Your certificate is being challenged, and you know that you can go to WAEC. Anybody can approach WAEC, and then you the owner of the certificate, you can write to WAEC, and they can, if it is your own, they will change the date of birth. The date of birth that is on that certificate. I want Arise Television to know, and the whole world to know, that the date of birth on that WAEC certificate that Sheriff Obero is parading is not his date of birth. His date of birth per affidavit that is sworn and age declaration that he presented is 19th of June 1963. The date of birth on this particular WAEC is 12th of November 1979. And since 1999 that certificate was issued, he has not deemed it fit to write to WAEC. If you had just got a letter from WAEC, because the law makes it very clear that no amount of affidavit can replace your WAEC. It just, if it's possible, then I will go and swear an affidavit at the Yaba Magistrate Court. I hold a master's degree from Harvard, and then I will just go to Magistrate Court in Yaba to swear an affidavit that I read medicine in Harvard University in Cambridge, and then I will swear it on oath. Does that make me a medical doctor? This is what Sheriff Obero is trying to do, and a lawyer is just trying to convince Nigerians that that is possible. Nigeria cannot condescend to the level where somebody who is holding a vital leadership position in Nigeria, like a governor, will not even have a mere secondary school certificate. So this is the issue. And I also like to quickly draw the attention of Nigerians to page 25 of the judgment of court, as it concerns the deed poll, which Sheriff Obero tried to make some futile attempt to try to bring in a deed poll to cure and to correct all the discrepancies and the inconsistencies in his names and in the various certificates. And the court hold that in view of this, the averment, I don't know if this can be put on page 25 of the judgment. In view of this, the averment in the further affidavit touching on what is termed the deed dated 7th of July 2011, i.e. Exhibit 5, which was deposed to by the first defendant, Sheriff Obero, to correct the discrepancies in his name and to renounce his old names, is not assailable in any way. It is illegal. On the face of the document, it is dated 7th of July 2011, as aforesaid, but was stamped by a commissioner for stamp duty on the 29th of April 1979. How this is possible is better imagined as it defies all logic. Furthermore, the certificate of Federal Inland Revenue Service showing payment of stamp duty on the document was issued on the 29th of April 2022, one day after the close of the governorship screening panel in Port Harcourt. These two clearly stand logic on its head, given the date the document was purportedly made, and the stamp of the Commissioner for Oaths. Then, Exhibit 6, i.e. the official gazette itself, recognizing the deed poll, signed by the first defendant, Sheriff Obero, is dated 5th of May 2022. With due respect, this court cannot give judicial notice in line with Section 122 of the Evidence Act 2011 to Exhibit P6, which is meant to be an official gazette of the Federal Republic of Nigeria. In what capacity did the first defendant, Sheriff Obero, sign the said gazette? This is a gazette, just 1 second, sir, it's very important. This is a gazette that you apply to correct a name, to correct the anomalies and the discrepancies in your documentations. And on this gazette, a gazette belonging to the Federal Republic of Nigeria, to be issued by the government, is signed by you, not the government who is supposed to issue it in your favor. So this is the level of forgery that Sherry Ivwurie went into.
Okay, thank you, gentlemen. What is certain is that both of you do not agree on what the details are. There is a pending court judgment. INEC says, just to clarify that the reason it has not announced anybody as PDP gubernatorial candidate for Delta is because it's waiting on the court, and that it's ready to respect the decision of the court. The window for changing the names of a candidate is still open till September 28, I guess. So there's still enough time to resolve this through the rule of law. And INEC says he submitted a name first because the portal, the PDP, Debo Uduaghan, said that he submitted a name first because the INEC portal was going to close on July 15, and that it received the court order on July 18, 3 days after. Well, these are some of the details, but let the court prevail. And on that note, we'd like to thank both of you.
Thank you. Please, sorry to interject you. Very sorry to interject you. I would like to respond to the issue he just raised concerning the deed poll.
No, but we're trying to close this.
Wait a minute to respond to the issue of... No, sir. He just raised a fundamental issue and he needs my response. If I don't respond, it's not a fair hearing. He raised the issue on the deed poll. I want to make it clear to you that submission of the judge is one of the reasons why we are on appeal. Because on the face of the deed poll, it was stamped in 2022, not 1979 as postulated by as ruled by the court. I have the deed poll here. Even when you present a document as this for stamping, they do what we call checking by the side. The check is 2022. The document was stamped in 2022, not in 1979 as ruled by the court. The ruling of the court is not before him. It is ruling on the basis of a document that is entirely not before him. It is not the truth. That is one of the basis of our appeal. And in his capacity as a speaker, he signed. Is he against the law? That is the question I'm asking him. Is he against the law? And is there any law that provides that if the age in your certificate is different from your age in declared, and as such, your certificate is a forgery? Your certificate is a forgery? No, I'm surprised. I expected that. I didn't want to join issues with him because he is not a lawyer. He probably do not understand the legal implication of certain things I have said here. I believe the lawyers that are viewing us, they will go to these authorities and they will advise him better that I have a better position. He's not a lawyer. He doesn't understand where the burden of proof sits. And he doesn't know whose onus it is to go to WAEC. He doesn't know how the Supreme Court, how the law works. That's why he's making several statements here. So I wouldn't want to join issues with him.
Let's wait in court.
He's not a lawyer.
Okay, gentlemen. We'd like to thank you very much.